Thank you. We will proceed first in the related matters consolidated for oral argument of In re Sakarias and In re Waidla. Hearing first from Mr. Gardner.
Good morning, and may it please the Court, my name is Cliff Gardner. I represent the petitioner Peter Sakarias. There are a number of matters, as I'm sure the Court is aware from reviewing the briefs, on which my colleague from the Attorney General's Office, Mr. Keller, and I disagree. And I'm sure we'll get to most of those this morning. But perhaps because we're at the Peace and Justice Center, I thought I'd start with a couple of points, three in particular, that we agree on, because it helps put our disagreement in great context, in the context that I think the Court needs to consider it in. The first point that we agree on is that in the town of Waidla case, the prosecutor asked the jury to sentence Mr. Waidla to death, at least in part, because he inflicted the fatal death blow, that he called it, and because he was the dominant character in the crime. The second point we agree on is that a few months later, he asked the Peter Sakarias jury to sentence Mr. Sakarias to death because he inflicted the fatal death wound, and because there was no evidence of dominance. And the third and final point that I think we agree on is that not only are these inconsistent, both of them cannot be true, but that at the referee's hearing, the referee made a finding as to why this occurred. And he found that it didn't occur because the prosecutor forgot his argument at the first trial. And it didn't occur because he'd come up with new evidence. It occurred because he wanted to maximize the portrayal of the two defendants in the two cases.
So the intent of the prosecutor is the paramount issue as far as you're concerned, as opposed to inconsistencies which could naturally occur in the course of presenting different witnesses or even the same witness who might change his or her testimony?
Well, the question of the importance of intent depends, Your Honor. If I can quote Justice Baxter's response to a question a moment ago, it depends. And it depends on the particular claim being raised. And that brings me to really the point of disagreement here, and that is, under this, what I consider a regrettable state of affairs, we've argued it violates the Eighth Amendment, it violates due process, it's introduction of false evidence. The state suggests that there's nothing wrong. Talking about the Eighth Amendment, I don't think intent does matter. I think it does with respect to those other things, the finding of the referee. But the Eighth Amendment issue, I don't think it does matter, and here's why. And here's why I think it's useful to start with the Eighth Amendment, because again, I'll start with a point of agreement. We agree, all of us, the Attorney General and I, that the Eighth Amendment requires a heightened standard of reliability in the determination that death is appropriate, and that presenting unreliable facts about the circumstances of the crime is going to necessarily undercut that determination. And that brings us to this case, and it brings us to this day. As I was preparing today for this argument today, I had been told that indeed we would be hearing questions from students. And I have argued many cases in this court for 20 years, and I've never had the good fortune to be able to ask a question in this courtroom, and I know that this isn't my day either. But as I was preparing, I thought if I could ask a question of Mr. Keller, I know I can't, but if I could, I would ask him what the state's position is today. Because they cannot argue, they cannot stand up and tell this court that they were right in the Waidla case all along, because that would be granting relief to Mr. Waidla, Mr. Sakarias, I'm sorry, the second defendant. And they cannot say that they were right at the Sakarias case, because that would require a grant of relief to Mr. Waidla. What they have to say is that they now don't know. And indeed, when you look at the state's pleadings, if I can look at the return to the petition for writ of habeas corpus, the state's current position is that it is entirely unknowable whether the hemorrhagic chopping wound was inflicted by petitioner or Waidla. That's the state's current position.
Well, Mr. Gardner, may I ask you this? Is it your position that if the ultimate hierarchical truth is unknowable, that the prosecutor in successive trials is precluded from arguing the most favorable from his or her point of view case in the first trial and then arguing an alternative view in the second trial? And if your answer to that is yes, the prosecutor is precluded from doing that, what can the prosecutor do?
Well, actually, the answer to that question, I think, is that that is a very difficult question, but it is not what we have here, because we don't have simply inconsistent arguments, Your Honor. What we have is the cherry-picking of facts, and it really points out the difference between cases such as Stump versus Mitchell in the Sixth Circuit and cases like People versus Watts here in California. If there's a case where a prosecutor simply presents inconsistent arguments, when the two juries have the complete record before them, that is one thing. But that is not what we have. And in fact, this was the essence of Judge Boggs' dissent in Stump versus Mitchell. What we have is a case where the prosecutor cherry-picked his facts. So what we have is manipulation of the record, inconsistent arguments, and then a decision by a jury based on a set of facts that we know one of those sets of facts is untrue.
What were the facts that were cherry-picked?
In this case, it primarily centers in testimony of Dr. Rebay. At the first trial, what the state did was they introduced Dr. Rebay's testimony that the back wound on the victim was consistent with her having been dragged, and that meant she was dead in the living room. The prosecutor took that fact and said that means that Waidla inflicted the hemorrhagic wound in the living room. Now, what he did at the second trial was he called the coroner to testify. He introduced all the photos but one, the one of the back wound, and he didn't introduce any testimony about the post-mortem nature of that wound. And that allowed the prosecutor to argue, no, she wasn't dead in the living room, she was killed in the bedroom.
Wasn't that evidence available to defense counsel in the second trial?
Yes, it was. And if the question gets at, question really gets at one of the state's primary defenses in this case, is that the adversary system can take care of this. If you disclose all the evidence, then really it's fair game for the prosecutor to do what he or she will. And I don't think the court should accept that argument. I don't think, I phrase that as the sort of sporting theory of justice. If you disclose everything, all bets are off.
Would it be possible for a prosecutor, without any new evidence coming forth, just to have second thoughts about the validity of the evidence and therefore not present it and therefore not have an intent to mislead the jury, but in good faith perhaps end up doing so?
Sure, and let's talk for a minute about the premise in that question, which is he doesn't have new evidence. Obviously, if a prosecutor does have new evidence, that's a completely legitimate reason for taking a new approach to the case, for taking presenting a new factual scenario and convicting someone else. That's entirely legitimate, as long as the prosecutor has some obligation to the defendant he or she is convicted first to remedy that situation. Absent new evidence, however, it's much more problematic. If the state does have a change of mind, it seems to me they still have some obligation to that first defendant. What the state cannot do is make mutually exclusive arguments, convict two people for a crime only one can do, and then say everything's fine.
Mr. Gardner, is it your position that in this case, if the defense does not put on enough of the defense, that the prosecution has to put it on?
Yeah. No, that's not my position. Obviously, the prosecutor's job is tough enough. The prosecutor doesn't have to try both sides of the case. But in the typical situation, for example, if there had been no Waidla trial, if we just had the Sakarias trial, and the prosecutor didn't ask those questions of Dr. Rebay, rolls the dice and figures maybe defense counsel won't do it, that's a slightly different story. He doesn't have to try both sides of the case. Having said that, he cannot present false evidence or false argument he knows or should know to be false.
And the false evidence that you're talking about in this case, the two acts, are you talking about the strike with the axe? That was attributed to both defendants in both trials.
Yes, the hemorrhagic strike with the axe. That's right.
Mr. Gardner, how do you reckon with the fact that what we have here is not one crime committed by one person with two people being convicted for that crime? What we have here is a horrendous murder, I mean as bad as any I've seen, and two defendants acting in concert to accomplish that murder. And we're focused now on which of the two defendants inflicted a particular blow. So my question is, what relevance or what consideration should be given to the acknowledged fact that these two defendants were acting in concert?
And the answer to that question, I think, Justice Baxter, is the difference between a guilt phase and a penalty phase. Were I making a guilt phase claim, I think the court would be legitimate, well within its obligation and its duty to say, counsel, what difference does it make? Under the principles of aiding and abetting, your client's liable for first-degree murder. It doesn't matter who struck what blow, and that's right. And indeed, that was the defense taken by the state. on appeal. What I tried to stress on appeal and what I'll stress now is that this is a very different claim at the penalty phase. Who struck what blows is not irrelevant to the penalty phase as under aiding and abetting principles. It is irrelevant to the guilt phase.
Well, doesn't it at least become relevant in terms of any harmless error analysis?
Oh, absolutely, absolutely. But if we're talking harmless error, let's then put it in context, because it's true what we're talking about is the harmless error analysis at the penalty phase, and we're talking about the jury's normative decision: should this defendant live or should he die? It's not a binary determination of fact who struck what blow. It's should this defendant live or should this defendant die?
Along those lines, counsel, didn't your client admit, I think, stabbing the victim multiple times and also admitted hitting her with the hatchet at least twice?
Yes, there's no dispute as to the post-mortem hatchet wounds, and there's no dispute as to the knife wounds. And so the question inherent in your question, if not explicit, is what difference does this make? And I think the answer is, there's really a couple of parts to the answer. The answer is it certainly made a difference to the prosecutor, who rolled the dice, argued inconsistently, and told the jury this was the critical consideration in deciding whether these defendants should live or die. And I say the word critical, that's the word he used. In the Waidla trial, he told the jury, the critical thing for you to consider is that he inflicted that death blow, with that massive force death blow. And he told the Sakarias jury that you might give him life, you might give him mercy, if he didn't inflict the death blow. So the prosecutor put critical reliance on that. It's one of the ironies of this case, where we're talking about a prosecutor's inconsistent arguments at trial, is that it forces the state to raise inconsistent arguments here, because now the state is coming and saying, yeah, the prosecutor said it was critical below, but it really isn't important. I mean, in a sense, it's happening again, and this is the kind of problem that infects the process. It's not just limited to the trial process, because it forces them to take inconsistent positions here.
Mr. Gardner, here, earlier in your argument, you relied, I thought, quite heavily on the Eighth Amendment, and I just wanted to get you back to that, because as I understand relevant law, in order for your client to be entitled to relief in raising an Eighth Amendment claim, your client would have to establish that the prosecution painted a materially false picture of the defendant. What is your response to the argument that in this particular case your client hasn't met that standard?
Well, at the risk of being obvious, my response is that we have met the standard, Your Honor, but let me explain why. Let me go beyond the obvious. My understanding of the Eighth Amendment is similar to Your Honor's. Perhaps I stated a little bit differently in that the obligation is to show that the death sentence is unreliable. It strikes me that when the prosecutor asks the jury to sentence defendant to die by saying one of the things that's most important, ladies and gentlemen of the jury, is that he struck that death blow, and then in post-conviction proceedings says, you know what, it's entirely unknowable whether he struck the death blow, that is the essence of unreliability. The state itself can't stand behind what it told the jury.
Would you agree that this case, I think we all agree it's a very difficult case, but would you agree that this is a case that presents a matter of first impression, or in your view, is there a particular case or are there particular cases that you think this court can get guidance from? And I'm looking at the federal arena. The first case that comes to mind is the 1997 case, the Thompson case, but as you well know, that particular case was eventually decided in bank. Then we have 11 judges participating in the decision. Before I ask any further questions, from your standpoint, is there anything in any of the decisions that were written by the various judges that participated in the in-bank proceeding that, from your standpoint, is helpful to your case?
Well, I won't limit it to Thompson versus Calderon, because the federal courts throughout the country, although this issue hasn't arisen many times, it has arisen on a number of occasions. The Sixth Circuit recently in Stump versus Mitchell.
I'd like clarification there. You mentioned that particular case, as I gather, that was decided in 2004, but I thought that in-bank review was granted in August. Do I have my notations right or
It would be
information
very
right?
difficult for me to ever suggest that Your Honor's notations are wrong, especially with your staff. I checked it. I didn't find that en banc review had been granted, but if it has, obviously it's no longer valid authority in terms of precedent. But it wasn't cited for precedent. It was cited for the reasoning of Stump versus Mitchell. But let's put Stump versus Mitchell aside. We have Smith versus Grouse from the Eighth Circuit. We have the federal sub-decision in Nichols versus Collins, which
How
was...
about the argument that taking a look at cases that have come out in the federal arena after the in-bank decision in Thompson, neither of the cases that you have just cited sheds particular light on what the various judges decided in Thompson. Taking a look at Thompson, one can get whatever one would like for support from the various decisions. You've got a plurality opinion. I think it was authored by Judge Fletcher, joined by 3 other judges, and there, citing or quoting general principles, and I think one decision from one judge in a circuit case, and whose name eludes me right now. But the Fletcher decision, the plurality opinion, simply comes to the conclusion, yep, you cannot, you, the prosecutor, cannot present inconsistent theories. That is a violation of due process. But then you take a look at the opinion written by Judge Tashima, was it right?
Yes.
Judge Tashima, and I think he was joined by one other judge. Judge Tashima agrees prosecution cannot present inconsistent theories. That is a violation of due process. But he then says, in this particular case, the defendant is not entitled to relief because it's impossible to tell which of the 2 versions presented by the prosecution was right. How about the argument that taking a look at this case, one can make the argument that taking a look at the evidence, it's impossible to say who did actually strike the fatal blow. Then we get to the Tashima position. How, from your standpoint, would that apply here?
Well, let's talk about Judge Tashima. Obviously, under Judge Fletcher's view, we win. Talking about Judge Tashima's opinion for himself and one other judge, Judge Tashima did find a due process violation, said, however, it's only prejudicial as to the defendant that can show what really happened.
And here, presumably, the other side, the one it takes the podium, is going to argue it's impossible to tell from the evidence who did what. Here we've got blows inflicted in the living room, and the fight is as to whether the fatal blow was inflicted while the victim was still alive. At the Waidla trial, we've got this expert, Dr. Reby or Ryby, whichever way the name is pronounced, testifying at the Waidla trial that because of an abrasion in the back of the body of the victim, he came to the conclusion that the fatal blow was delivered in the living room and not in the bedroom. And so again, back to my original question, your response to the argument that it's impossible to tell in this case which is the true version, who did what, who delivered the fatal blow?
My response is simple. First, Judge Wilhite himself made a finding as to which of these 2 theories was probably correct. And Judge Wilhite's finding, of course, was that the great weight of the evidence supported the theory presented in the Waidla case. And the state hasn't taken issue with Judge Wilhite's finding. That's the first point. The second point is that a week before we had the evidentiary hearing, we had a motions hearing before the evidentiary hearing. And I offered, based on my witness list, to present evidence, forensic testimony, to show exactly where the victim died, and thereby showing exactly who had to inflict that hemorrhagic wound. The state objected to that evidence. In the argument on that evidence, I said, there's an opinion by Judge Tashima which requires this for prejudice. And I think Your Honor should let this evidence in so that if we get to discuss Judge Tashima's view, I can establish prejudice. The state objected to that evidence, kept it out, and the court sustained that objection. Now, it strikes me that there's something unfair, and in fact, Joseph Heller would probably call it a catch-22, to allow the state to object to my evidence of prejudice under Judge Tashima's view, and then stand before this court and say that under Judge Tashima's view, I haven't proven prejudice. The court can look at the record. You'll see that Judge Tashima's opinion was actually cited in the discussion of why I should be allowed to introduce that evidence. So the response is really twofold. I think we can tell which of the two theories is correct. I think we satisfy Judge Tashima's view by virtue of Judge Wilhide's finding. And indeed, Judge Wilhide's finding is based on what I consider, he correctly assumed, was the great weight of the evidence that shows, indeed, she did die in the living room. But putting aside...
She did die what?
In the living room. And if she died in the living room, since there's never been a theory that there was a change of weapons...
What is the particular piece of evidence that leads you to the conclusion that the victim, whose skull was almost severed, did indeed die in the living room before the body was dragged into the bedroom and more hatchet and knife wounds were inflicted?
Yeah, there's a number of pieces of evidence on which Judge Wilhide relied for his finding that the great weight of the evidence supported exactly that theory. First, of course, is the blood pool that was in the living room. There's an enormous blood pool in the living room, which is typified, I'm sure the court sees this in many awful homicides, of someone bleeding out in the living room.
Is that related to the what the expert called what was the term that you mentioned earlier? Hemorrhagic?
Hemorrhagic.
And non-hemorrhagic and
No.
hemorrhagic? No?
I'm not there yet, but I'll get there in a second. There's a large blood pool in the living room. There's no blood pool in the bedroom, suggesting that she didn't die in the bedroom. There are the drag marks from the living room to the bedroom, showing that indeed she was dragged. We then get to Mr. Rebay's testimony, the coroner, where he testified that that was a post-mortem wound on her back caused by being dragged along the carpet, which means she was dead in the living room. And indeed, that's exactly what the prosecutor used that piece of evidence for in the Waidla trial. Again and again, he told the jury, we know she's dead in the living room.
But didn't the same expert at your client's trial, having said something rather different at the Waidla trial, but at your client's trial say, well, yeah, she could have been alive before being dragged, and I think at one point he came to a different conclusion, saying no, she must have been dead in the living room and then she was dragged. But I think, unless I'm getting my facts confused, that at your client's trial he came to a different conclusion, or said, or basically acknowledged, yeah, you know, it could have been one or the other.
Actually, at my client's trial, the area wasn't mentioned, and that really is the vice. The prosecutor did not ask Mr. Rebay at my client's trial, is this a post-mortem wound on the back? Is it consistent with being dragged along the carpet? He did not ask, and that allowed the prosecutor, in the absence of that evidence, to tell the jury that, in fact, he was alive when dragged back to the bedroom.
May I pick up on that point? As your time is coming to a close, I'd like to, well, I don't know if it is or not, but I'd like to have you I'd like to have you articulate the theory, the holding of law that you want this court to apply to your client's case. And here I think you say there was manipulation of the evidence, so we're not just dealing with inconsistent arguments. Would you articulate?
Yes, I'll articulate actually two theories. In the Eighth Amendment context, my theory is very simple. Where the state has put forth a theory at trial and in post-conviction proceedings admits that it doesn't know if that theory is true, if that theory was central to the jury's determination, there's an Eighth Amendment reliability problem. As far as the due process issue, which we've just been talking about, I think the court should draft a very narrow decision. I don't think, in this area, the cases are very complex and they're very fact-driven. And I think the court should issue a very narrow ruling that says when you have manipulation of the record, and by that I mean cherry-picking of facts, when you have inconsistent arguments in addition to the cherry-picking of facts, and certainly when you have an explicit finding by the referee, a finding which isn't contested by the state, that the prosecutor did that not because there was new evidence, not even because he forgot, but solely so that he could tack two skins to the wall rather than one.
Is it important that it was the same prosecutor?
You may respond to Justice Chin's question, but your time is otherwise up, assuming you wish to reserve your time.
Yes,
And can I add to it, would it make a difference if it were two different prosecutors?
In the context of the Eighth Amendment, no. Ultimately, it's unreliable. If the state in post-conviction looks this court in the eye and says, we don't know if the theory we presented is true, it doesn't make a bit of difference. And indeed, that's consistent with cases like Caldwell versus Mississippi, Johnson versus Mississippi, where the prosecutor's good or bad faith is irrelevant. In the context of the false evidence component of the claim, presentation of knowing or false evidence or evidence he should have known was false, again, it doesn't make a difference under cases like Giglio, where there were two prosecutors. And there were sound policy reasons for that.
Thanks, Mr. Gardner.